Hi everyone, this is John Girardi from Right to Life of Central California, bringing you another in our 40 videos for 40 Days for Life series. 40 Days for Life is the international campaign of prayer and presence outside abortion clinics throughout the country and throughout the world. If you want to learn more about our campaign here in Fresno, please visit rtlcc.org or get in touch with us at Right to Life by calling us at 559-229-2229. Starting today and for the next few days, I'm going to talk about some of the most important Supreme Court cases that kind of governed the practice of legal abortion in this country. And I think for this first video, though, I want to talk a little bit about what the world was like, what America was like prior to Roe v. Wade, and kind of explain some of the history of it before we actually get to Roe itself. Prior to Roe v. Wade, most American states banned abortion. Now, if you go back to the time of our founding, America is, like most former British possessions, a common law country. We're governed by the common law system. And the common law system is a system of judge-made law. Basically, law gets developed not by writing statutes so much as by judges issuing decisions in a given case and handing down those decisions in a system of precedent, and over the course of time, honing different definitions of different kinds of legal concepts. A lot of the basic definitions of a lot of criminal law concepts, contract law concepts, tort concepts, come to us today from those common law decisions by English and colonial American and early American judges. So America was a common law country. And in 18th century, early 19th century America, you didn't have any statutes on the books opposing abortion, but you had a number of decisions by judges about the question of abortion. And abortion was very clearly disfavored at common law, particularly after quickening. So quickening is, the word quick is kind of an older English word that means alive. So quickening is the point in pregnancy when the baby comes alive. Now, you're dealing with 18th century embryology here, and they basically thought once you could feel the baby moving in the womb, that's quickening. And that's what the term quickening means. It's the point in a pregnancy where a woman can start to feel the baby moving. After quickening, American states would be favorably disposed towards prosecuting individual acts of abortion. And while there's less evidence of prosecuting abortions before quickening, it was still apparently done occasionally. Now, the importance of quickening was not so much that, abortion after a baby is alive is bad, but before quickening is totally fine. Quickening was a kind of evidence principle that you know you're pregnant when you can feel the baby moving. Again, this is a world before ultrasounds, okay? So that was sort of how colonial America viewed this. Now, in the 19th century, some big breakthroughs happened with the study of embryology, and we learned that human life begins when a zygote is formed. An egg cell and a sperm cell meet and form the first cell of a new organism. That was discovered in the 19th century, and it led to this revolution in American states that they would pass statutes very clearly banning abortion except to save the mother's life. This was done throughout the course of the 19th century, around the time of the Civil War. So that was sort of the state of things in the United States up until Roe v. Wade. Some individual states passed legislation to give more permissions to abortion, but things were regulated on a state-by-state basis. California and New York had passed laws that were a little bit more permissive towards abortion, but most states had statutes on the books, many of them from this sort of Civil War era, this mid-19th century era, banning abortion as a criminal offense. Tomorrow, we'll talk about Roe v. Wade and what Roe v. Wade really did and how really revolutionary it was in horrible ways. We'll see you tomorrow in our 40 videos for 40 Days for Life series.